So we are. So the committee looks a little lopsided. Everybody's sitting on one side, which means I just have to turn my head to the right to converse, which is probably good. Oh no, you're fine. And I think, if I recall correctly, I think Representative Weldon is Chairman Weldon is at in a hearing this morning in court this morning, so he may call in and join us shortly. And then Representative Chairman Wendell Willard, I think he may join us, but we'll just have to see if he gets here in time. What you have before you is on the front table here is a stack of the proposed recommendations. It's a draft recommendations version 3. This is a document that we have somewhat vetted over email and through telephone calls with committee members, given that we're so far apart. But we wanted to go over those recommendations today. Okay, thank you. Yes, ma'am. Thank you. And then in addition, Representative Oliver has some changes that we have up there on the front table as well. So we'll go through those as well. And if any member has any other changes as we work through the document, please feel free to let's make those changes known. Every member has a copy of Mary Margaret's revisions as well as the draft version 3 report. And what I intend to do here is we're going to go through each one of these individually, but I wanted to allow the committee members to ask questions of individuals from the departments or from organizations that are here today or individuals. So if you have questions as we move through the report, I don't want to hold you up from doing any number of things, but two major things are feel free to ask questions of the folks that are here today from the public and from the state, as well as, let's make edits where we see fit, so feel free to make recommendations and changes as we go through the document. We'll try to do that in a swift fashion, but at the same time I don't want to hinder the discussion. The other aspect, and Ms. Houston, can you hear us on your end?
Yes, I can hear. I have it on speakerphone. Hear you well.
Okay, good. Very good. Thank you. And then I think if anyone from the audience would like to comment or has a particular concern with what's written in the document, now is your time to express those to us. As we move through the items, though, if you have an issue, raise your hand. That's the best way I can say to do it. Raise your hand, come up to the podium, and let's talk about that particular issue moving forward, and then we'll go through it step by step. And so with that, is there anything else for the good of the committee before we begin? Okay. Has everybody had a chance to look over at least the draft version 3? And I think Representative Oliver's recommendations are made in red or track changes, so you can see them quite quickly through the document. Also, I wanted to again thank, before I forget, I want to make sure that I thank Department of Juvenile Justice, Department of Human Services, the Department of Department of Human Health and Department of DBHDD, and the Department DCH also had provided some information on this. All of these departments, I want to express our sincere appreciation for your input, for the ideas, the very fruitful discussions that we've had both online and offline, so to speak. The information you provided has been very helpful in guiding the committee. And I appreciate you coming and attending all of our meetings. Also want to express my appreciation to those members of the public-private organizations that are working in cooperation with our state agencies that are providing their child care providers. There are unified groups such as Together Georgia that is working with a number of different CCIs and CPAs. We appreciate their input. The Barton Center has also provided some input in this process. We want to express appreciation to the Barton Center and several others that I know I'll forget, but I want to express that appreciation. And then, of course, my sincere appreciation to the members of the committee for their steadfast participation in this process, and for their comments and suggestions. And I apologize, I've got a sinus infection, so I'm taking some medication for that. So I apologize for my stuttering through this. But let's move through it, and I'll start with the first page. The first page just deals with an introduction and an expression of gratitude on behalf of the committee. Are there any changes that you would like to make to this? We will delete that draft version 3 off the top.
But this is the one we're working on.
Yes, draft version 3 is the one you have. So with that, looking at draft version 3 on the first page, the only one I'd like to change is the term multi-hour meetings in the first paragraph. It's the fifth line down, and that's just to express the accuracy that hopefully we won't be here multi-hour, but we could be. But if we are not multi-hour here today, then I'd like to just remove that, because that would be more accurate. The other, anything else on page 1 for the committee members? Any comments from the public? All right. Page 2 deals with findings and recommendations, begins with the first set of findings and recommendations concerning consolidation of certain annual inspections. The paragraph is quite lengthy in trying to isolate some certain findings there. Are there any comments or suggestions, criticisms with respect to paragraph 1A, which is dealing with the findings of the committee on these particular items? And it rolls. Let's just focus on page 2 right now, because it rolls over to page 3 and 4. Tom calling in. No. All right. If we could, we'll turn to page 3, which rolls over with more additional findings of the committee. These are number specific on the first full paragraph that's on page 3. These are specific numbers that were provided from ORCC and then from OPM later down at the bottom. But those numbers are they somewhat varied, and there was a little bit of inconsistency between the OPM numbers and the RCC numbers, so we may want to take a look at those. But Ms. Winstead, when I recalculated the number of surveys per inspectors on the spreadsheet, I think it said 74, 76, something like that, surveys surveys per inspector, and I think I came up with 54 when I recalculated it. So that number may need to be addressed, but I think I remember there was a mathematical issue with respect to those numbers there, and that's so I put in 54 based upon my calculation, and this is about right dead center in the page. If there's any if you want to speak to that, to the number of surveys per inspector and field surveyor, that may be helpful. If it's the right number, that's fine. Okay. These are all the numbers from your presentation. The only one that is different is the number of surveys per, and I think I remember there being a discussion about that number being off. So if you'll take a moment to look at that, we can correct it later on as we go through. I just wanted to highlight that for the committee and for the public. The rest of the numbers are taken straight from the information provided by each department. That's also true for the information related to OPM on the second full paragraph on page 3. All right, I'm going to just mark this and we'll go back to that number if we need to. With respect to the recommendations that begin, this is recommendations 1B on page 4 of the report. These are the recommendations coming from the committee concerning consolidation of certain inspections. And I'm sorry, Representative Oliver, you had your light on? No. Okay. Representative Tanner?
I just wanted to make a comment on the recommendations there on B. I don't know how difficult it will be for the agencies to do this, but I will say that I think it would be very helpful to everyone involved, and also could be a time-saving measure if this could be at least looked at. I know being on a bank board, dealing with the FDIC and the state banking department, they rotate which agency takes the lead in doing those exams. That process seems to work very well. So if there's a way to do some additional research by the agencies and give this careful consideration, Mr. Chairman, I do think this would be an appropriate recommendation.
Okay. Did you want to add to that the suggestion that it be rotated, or do you want to let them?
I would leave that personally up to the agency's discretion. I just state that from personal experience dealing with the banking department, I know that they rotate who takes the lead in the exams, so that they come together, or they allow the other agency to take the lead and provide the report for both agencies. And then the next time the exam occurs, then it's the other agency that takes the lead. So that's just a suggestion. I don't know that I'd want to make that as a recommendation, but just something for them to consider.
Okay. Thank you. Any other comments? Yes. Mr. Scroggie, come up, and if you come to the podium, if you go to the podium, the reason why is that folks that are online, specifically Ms. Chairman Houston may not be able to hear you, so I want to make sure she can.
I'll be quick. I thank you for your opportunity. About midway through the first paragraph where you say this inspection would still be unannounced but would be scheduled in the manner RCC currently schedules its inspections, I would just simply ask that perhaps you consider a recommendation where it's not done the way it currently is done, but perhaps there's a blackout period utilized, such as they do with Joint Commission, other type of accreditation visits where you're doing your annual inspections, where at least there's some opportunity for the provider to say, like when the executive director is going to be on vacation or people are going to be out of the office, and so they still can schedule in a block of time, but there's some consideration taken in for these annual inspections to have some input by the providers. And if you went to a Joint Commission type of inspection for that, it would be called a blackout period, where they give you a block of time, and you can say during that block of time, these are the 3 days we'd prefer you not come because of various things going on, training, staff are being trained that time, et cetera, et cetera. So I'd like for you to consider that.
Thank you, Mr. Scroggie. Appreciate that. I think that the sense that I gained from the committee was that that the unannounced visits were very helpful in providing an accurate sense from the regulatory agencies as to what the goings on are at the particular facilities and homes. And the other is that the way that I understand RCC to currently schedule these is that it's within a 30-day window. So there is, in a sense, a blackout period built into the way they approach it. Now, that may be inaccurate, but that's the way I understand their approach. So that it's done every year, and then there's a 30-day window about the time that it's going to happen from the last inspection from the previous year. Let's discuss it, because I'd rather us know. Okay, very good. Representative, go ahead. Yes, Ms. Kelly, go ahead.
Sure, sorry. I actually like the idea of adding the rotating option to this, because the way it's written, it seems like we only have one thing that we can consider, which is consolidation. So if we could add the rotation option, that would be great. And then also I noticed that there wasn't a deadline date to report back like the other ones. So if we could have that added in, that would be helpful as well.
Report back on?
The other ones give us a date that we need to come back with recommendations, or it's like one said December 1st, there was some legislations that needed to be brought back. One says November 1st, 2015. So I'm just trying to figure out how much time do we have to take a look at this.
That's a very good point. Thank you very much. Representative Oliver.
I think that the blackout request may be appropriate. I want to suggest, following the sentence, the inspection would still be unannounced but would be scheduled in a manner RCC currently schedules its inspection, possibly adding a sentence, and this is for discussion, child care providers shall have an opportunity to provide up to 3 days as a blackout period within an estimated 30-day period of unannounced inspections. I'm trying to figure out who they're going to report that to with this rotating. That's why I was stumbling a little bit.
I think my concern with setting up a scheduled blackout date is it essentially doesn't provide for the unannounced visit that can provide more information. If it would seem to work better if the provider knows that within a 30-day excuse me within a 30-day period of their annual inspection, that they should know at that point in time that they're going to be out of town, they're going to be in training, and it would seem to me that it would be better for the provider to report that back to, and it sounds like what you're saying, but instead of 3 days, just telling them when they're not going to be available, provided that that's not every day except for these 3 days.
There's only going to be about 20 days available in a 30-day period, roughly, of work days. Are you agreeing with me or disagreeing with me? I couldn't figure it out.
I'm agreeing with the reporting back from the provider, reporting back to them, but the blackout period, I think there should be a level of communication between the provider and the agency. I don't know that I want to specify that there be any particular formula that we utilize other than communication between the agency and the provider.
So the suggestion of modification of the child care provider shall be entitled to suggest to the inspecting agency days that are where certain key personnel will not be available, and the agency may or may not choose to honor those days. That's a slight modification. I want it clear that the agency can say within this 30-day period, please don't do it here away, and then but whatever you think, Mr. Chairman, I'm comfortable.
I'm going to turn everybody's lights on so you can just talk.
Well, I may have misunderstood your recommendation. If I did, let me know. But it sounded to me like what you were recommending is that if there is 2 days that the director is going to be gone within that 30-day period, they can notify the agency that these 2 days we're not going to be available, please don't come. It's not that you're giving them 2 days to come. You're just, so it's still unannounced. You're just saying our director from between June 1st and June 6th is going to Hawaii, please don't come those dates. Is that what your recommendation? And I think that's the same thing that you're saying. I don't know would the agencies have a issue with that kind of coordination back to the back from the agencies.
Good morning. I'm Raquel with the Department of Juvenile Justice. I was going to speak to that piece. I think we had talked about possibly putting a unified calendar in Georgia SCORE so that we can actually see when those actual joint visits would occur. But I don't think we would have an objection to actually knowing when the dates when the directors would not be there, because it would be beneficial for them to be there.
And I think if it gets if you've got an agency or a provider that is giving you too many dates that they're not available, then you can address that. But if it's reasonable, then it seems like it would work.
The blackout is that. So that's a blacking out of 3 days, a maximum of 3 days within that 20-day period. Is that what we're saying?
That was my suggestion, Mr. Chairman.
And one last thing, Mr. Chairman, I was just based on the department's recommendation and based on what I said earlier, I would propose that we go ahead and add in that this be rotating between, the responsible agency would rotate, where, and you can word it better than I can, Mr. Chairman, but an inspection done by a single inspector on behalf of RCC, DFAX, DJJ, DBHDD, and that would rotate, the responsible agency would rotate. That was my recommendation. It sounds like the department's good with that also being included, so I would recommend we go ahead and put that in the report.
Any problems with the committee members with that?
Good suggestion.
I think Mayor Margaret will put the, Representative Aller will put the suggestion that you had. Now I understand
Okay.
it better. I did not at the time. Thank you.
And is the reporting to be done to the agency that is in charge, or to whom? Does that need to be cleared up?
I think that the CPAs need to report back to the contracting agency, and the licensing agency would be it'd be RCC, and then OPM if you have a contract with OPM, or would be with DJJ if you have a contract with DJJ, etc. Yes, Ms. Winstead.
I may be confused. Wouldn't be the first time, but I'm mixing up. It sounds to me like we're talking about two different issues, so I want to make sure that RCC is at least clear on that. But as far as the RCC is totally on board with, and we currently do it. It's just not a lot of people take advantage of it. But currently, we allow providers to tell us, they call me all the time and say, we're going to be gone during this week. Can you avoid that week if at all possible? So we have no problem with that change and revision being put in there. As far as the multiple agencies, one person doing the work of multiple agencies, I certainly have a lot of concerns about that one. But as far as the rotating of who would actually be responsible, I'm assuming that you're talking about doing legislative change for RCC to not be the licensed authority? Or?
Here's how I read it, Mr. Chairman, but you want to answer that question first?
No, go ahead.
I would personally, I'm only speaking for myself right now, I would rather give your agencies a chance to work together on a plan for rotating this work, so to benefit yourselves so that you're not duplicating staff time. I think it's going to be a little bit of a difficult task, but I think it's doable. It's DFAX is going to have the greatest number. Behavioral health and DJJ will have a lesser number. And I believe that if y'all sat down and talked to each other, you could work out a plan. If you can't work out a plan in X amount of timetable, then I would only then would I want to look at the North Carolina statute. I look at the North Carolina. I don't know how the North Carolina statutes worked. I don't have any information back. I don't know if anybody does. But it was. I would rather not require. I would rather not draft a piece of legislation for these several 4 or 5 agencies. I would rather you work together as a first step, and that's what I understand the intent of this language is, Mr. Chairman. Correct me if I'm wrong, please.
No, I would agree that the first paragraph there is a directive to the agencies to consolidate your inspections, and with a recommendation of Representative would be to rotate them as you see fit. Now you're going to have to work those out. Now I think that what you're getting at, Ms. Winstead, is that you have a mandate, a statutory mandate of an annual inspection, so that's going to happen. And I think that's a legitimate concern. That maybe have to be a modification in that to allow for this.
Correct.
And so I think that's a very good point. But the intent here is really to get the agencies coordinated amongst themselves. Alternatively, if that cannot be worked out, within a time frame that I think Ms. Kelly was referring to, putting that in here, then we need to look at it legislatively. But the intention is to allow the agencies to try to work that out first.
I guess the wording that confused me was the single inspector, and I'm interpreting that as one person. Is that the intent, or does it mean a single team going out at the same time?
It means a single entity, person or team. And again, that's something that I see y'all as most appropriate. If I were going to sit down and try to draw legislation for that, I would not be able to do it competently with as much thoroughness as y'all should be able to do it working with each other, is my thought.
I think that we can.
Because I can see us attempting for DJJ and OPM, and when applicable, DBHDD, trying to go out together to do a team survey. I don't see the feasibility of DJJ teaching an RCC person how to do their job.
I think that the problem with the team approach can be for smaller entities to be overwhelmed with the number of agents that come in. So I think the proper rewording of where it says single inspector should be single inspecting agency instead of inspector, to accomplish, I think, the recommendation of this committee. That will give you the clarity of it not being necessarily just one inspector, but if you have to send multiple persons, that's fine, but the point of this is not to overwhelm the provider with every single agency, but to send one agency to collect the information on behalf of all of the various agencies that are regulating that particular child care provider. So it will create some difficulty, but we're optimistic that the agencies will come together and figure out the appropriate checklist for each of these inspecting agencies to go ahead and then whatever rotation works out best. We hope that you'll be able to figure that out amongst yourselves.
Okay, and then my final thing is just, I guess I really don't want to lose any specialty services by any of those agencies, like, having your heart specialist and your orthopedic doctor send you to one doctor to do both and just teach them what to look for. I want to make sure we don't lose the important things that DJJ, particularly DJJ, more so than OPM, because their work is very different.
Thank you for those comments. Speaking of DJJ.
Speaking of DJJ, how are you, sir? Thank you for the opportunity to come before you today. As I sat there, I thought about the impact where transparency is all so important in state government, and the efficient way of doing business. There's just sometimes difficult when we, as public safety entities, in the scope of services, the degree of that somewhat may be different than that of a DBHDD. As it relates to some of the compliance issues that happens that the providers must do. So I find it difficult that depending on whose time it is to inspect, don't necessarily take into consideration the importance of that public safety entity, as well as what DJJ is required to do. And that's just my concern from an agency head. I know that each one of the other commissioners will work to make this as seamless as possible, and provide the transparency, and then the efficiency of state government. But keep in mind that those technical aspect of that inspection is so different. But yet, you know, we got one come and go, then that's to make sure that the providers are providing the services that we need at the state level. But I do caution us when it pertains to that the Department of Juvenile Justice is set out.
Mr. Commissioner, on page 2 of the draft, we have a lot of numbers here that's been helpful to me in relation to the number of inspections. And I'm backing up, Mr. Chairman, but I don't see that this page includes numbers of DJJ inspections. And I'm just trying to get a comparison of my mind, the numbers that DJJ does, similarly to DHS, versus the ones that behavioral health may do. Do you have this 89 child placement agencies, 175 child caring? How many entities do you inspect? These are private entities, DJJ.
Okay, yes, ma'am. Are you speaking from the PowerPoint from our first meeting for DJJ?
I'm just asking for a number. I can't remember.
Okay, of those 89, that's basically our number of vendors that we have for the agency.
No, you're talking DJJ or
yes,
DHS?
Yes, ma'am. Yes, ma'am. DJJ. Of those vendors, we actually have about 45 inspections per fiscal year, which is probably equate to about 2 per vendor, 1 announced and probably 1 unannounced. So those numbers, I can give you more specific numbers, but to equate to that number for visits per year, that would be equivalent to the DJJ visits that we do for announced and unannounced visits.
I'm just trying to figure out, does DHS have twice as many? Is that what we're seeing, or they have?
No,
you're using the same 89 number. I'm confused.
I think that out of the possible licensed vendors, there's 89 possible vendors
Total all agencies.
But they have contracts with 45
that are probably joint vendors for both DHS and DJJ.
So I didn't know that. I didn't know it was that many.
They have a few, and they have actually a few that are specialty.
Yes.
I think it was 7. Was it 7?
Yes.
I'm sorry, I didn't put those in there.
Forgive me, I understand now.
Okay.
So it's not as disparate as I thought. DJJ has many. I recognize that there's a different statutory public service that you're providing.
Yes, ma'am.
But I also recognize that you, DJJ, and DHS and behavioral health need to talk about and coordinate some form of joint inspection. That's my recommendation. And to the extent you're not able to do that, in whatever timetable the chair thinks is appropriate, I'm curious about exactly why. And then that would lead me, I'm just speaking for myself right now, if we suggested that you do this, and X number of time you come back and say, I can't do this because of these statutory conflicts, then that would lead me at that point to start looking at the North Carolina statute and a lot of statutory revision. Yes, and I'd rather not go there myself today. I would rather ask you all to sit down.
Yes, ma'am.
I don't think it'd be a useless task for y'all to try to look at this, recognizing that you have very different statutory responsibilities.
And I think it goes to the kind of the fundamental balance between ultimately what we need are facilities. We have to have safe facilities that work and that provide the care, the protections, and the monitoring, and the greatest degree of normalcy that can be provided to a child so that they're able to adapt when they move out of the system. And what we're doing is trying to balance those needs, because ultimately none of this works if we don't have providers. And if providers are feeling as though it is difficult, A, to enter the system if they want to be providers, or B, that they're in the system and that the burdens take away tremendously from their time. As we heard information this morning that it's costing Chris Kids 70 on average across providers. The survey that they had done was about $78,000 per year of time and effort to try to comply with the inspections that they're presented with. For the eight facilities that particular organization has, they have 24 set inspections just for those eight homes. So that's DJJ, DHS or OPM, and then RCC. So you can see the enormity in which the providers are faced in terms of inspections. That's just annual inspections. That doesn't deal with the child-specific or incident-specific inspections that they have to go through. So we're trying to weigh both your need for oversight,
Yes, sir.
as well as with the practical needs of what's the impact of the providers on their end to to provide the services and do it well. So that's, I think, the balance. Mr. Commissioner, I thank you very much. Ms. Watson, thank you very much for your. But what we'll do is I will make sure that the report is amended, because I want to make sure that I get DJJ's numbers into the report. I think that's helpful for readers to understand the magnitude of the work that you're doing, the number of providers that you have to contract with, and I did not put that in there, but I think I need to.
Okay. Thank you, sir.
Ms. Winstead, yes.
Mr.
I rechecked the numbers. Every time I add it, I still get the 64 that I had on my slide.
Mr. Chairman, I was just going to also add that I think the committee's intent here, too, is to set a framework that we feel like there needs to be a conversation. There needs to be a way to consolidate some of these inspections. We're not dictating how that's done. It may be that you come back and say, look, we need a DJJ inspector at every one. We're going to partner with the other agencies and do that because what we do is so unique. But I think there needs to be that conversation before there's any legislation. So I think it's important to know that from an outside perspective looking in, we may not have all the answers, but it just appears that there's a lot of people going out to kind of do the same thing. There may be a way to combine some of these efforts. So,
Mr. Chairman, will you also include a time frame in the recommendations, please?
Yes, and Ms. Kelly, you suggested a time frame. I would. Ms. Oliver has suggested time frames in her responses back to inquiries on this particular report, and she's used a 120-day period of time. So I would suggest that we make a recommendation that, with respect to the first paragraph under recommendation 1B, that this be that an analysis of how the agencies will perform this consolidated function should be presented back to the committee within 120 days of the issuance of this report. And then I noted we also have Mary Margaret's change here at the end of on the 3-day blackout, and Representative Tanner's change on the responsible agency rotation. We're changing inspector to inspecting agency in this paragraph, on this recommendation section. Any other changes to the recommendation sections for paragraph 1B? I'll note that Ms. Winstead has corrected me, and on page 3, going back to the amount of surveys that are done per inspector per field surveyor, that number will be changed to 64. I have it as 54, and that may have been my mathematical error, but we will change that to 64. All right, let's move on to criminal background checks then. This is the next topic. This resulted in a lot of discussions, and then also I want to thank Ms. Kane, who's here today, from DHS. There was discussions about the the differing needs that each department has to have with respect to the criminal background that they're checking, the activity that they're going to check. And that varies from agency to agency. But at the same time, the fact that it has to be done multiple times by multiple different agencies for contracting purposes means that one employee or one staff member or even one guest at a home has to be checked in different ways. This creates a lot of turnover in terms of the background check. So I think the committee was looking at how can we consolidate that. There are some legal hurdles that we have to deal with respect to the federal level. And so what I put in here is just a couple of suggestions on how to proceed. And this is after discussions with Commissioner Horton and Ms. Kane from DHS. And I appreciate their input on this process. Any comments on the finding sections of Part 2A?
I just have a question, Mr. Chairman. The criminal background checks that we're talking about here, is that running a criminal history through GCIC and NCIC?
Yes, sir.
And
Ms. Kane is here.
So I understand that the agencies are probably looking at different things in that criminal history, but I'm assuming when you run the criminal history, they're all being run under the same purpose code. So the information you're getting back, I guess my question is the criminal history information, whether it's run by DJJ or it's run by whoever, is the information that they're getting back on the printouts the same? Is that correct?
Both RCC, as part of the licensure function, and DFACS, as part of the child welfare contracting section, have a code W is what they run those criminal record checks under. I can't speak for DJJ, but there is a child welfare code specifically for these checks. It's different than the E, which would be the employment code. The issue that Representative Welch was mentioning, we had some conversations about how to go about doing this. And in looking at the recommendation, we volunteered to redraft a letter to send to the Attorney General in an attempt to draft a coherent, rational letter and be able to phrase this question. Obviously, that led to more research, and as often happens, more research led to more questions. And what we've discovered since we met with Representative Welch is that the GCIC is the Georgia Criminal Investigation Center. It's run by the GBI. It is the central agency. It's authorized as the repository for criminal record checks within the state, both at a federal level, and then the GCIC itself has its own statutory authority under Title 35, Section 3, or 35.3. I believe it's 30 at SEC. I think it's they have an actual statute specifically for agencies that engage in elder care, child welfare, and that's 35.3, 34.2, and it sets out some very specific requirements for the sharing of information between these agencies. It also sets out some pretty hefty sanctions for unauthorized sharing within the agencies. While we could, as the state of Georgia, draft a letter to the Attorney General, I don't know that the appropriate section would be the Department of Human Services or DJJ, simply as two sections of the executive branch. We would probably need to go through GBI to determine whether or not we'd even be able to get there. So when we look at what we're trying to do as far as a sharing of information, I don't think that there's any problem sharing, or I don't know that it would be a problem necessarily for RCC or DFACS to obtain a criminal record check under the same code. The issue that we seem to be running into, for the most part, is the timing of that code. So let's say somebody comes in and applies for a license. At the time they apply for a license, we are authorized to use that background check for that particular purpose, for that particular time. DFACS, as it turns out, we found out recently that DFACS does not run an additional licensure check on the facility itself. What ends up happening when once you become licensed and you want to come into DFACS and become a contractor with DFACS, what DFACS requires is confirmation that you have undergone the RCC licensure process. So the provider sends a copy of the letter that the provider receives from RCC saying, yes, you've gone through your background check, we've got your criminal history, the named providers and all of your employees have been checked, and here's your letter, essentially. We request that that provider turn around and give that same letter to DFAC, so they don't undergo a second set of criminal record check requirements specifically for the contracting piece, which is, quite frankly, information I found out within the last 48 hours. What is asked is that if any new employee, if there's been anybody that had been hired since the time that RCC did that original criminal record check, that employee undergo a check. And those record checks are apparently good for 60 months, 5 years. So when we look at the record check piece of this, I question whether or not we've asked all the right questions to determine truly what are we trying to fix here. But as far as going to the Attorney General and asking for the ability to share it, what we found is that it seems pretty clear in both federal statute and state statute that because the criminal record checks are good for the purpose for which they're given at the time that they're given, from a licensure perspective, we're trying to comply with that. And then from a DFAC's perspective, we do permit that criminal records check to stand for 60 days as long as you aren't a new hire, if that makes any sense.
I guess my initial question, though, is the background check we're talking about is just running a criminal history. We're not, because in the report it says the extent of the background checks vary depending on the regulatory agency scope of authority. I'm not sure that's necessarily correct, because if we're all being run under Purpose Code W, then the information, the criminal history check, is all the same. It may be done at a different time for a different purpose, but the information you're getting back is different. DJJ is not sending a field investigator out to go to the neighbors' houses to check on an employee. So when we're saying, because coming from a law enforcement perspective, there's a lot of different kinds of backgrounds, but I just want to make sure that what we're talking about is just running a GCIC criminal history. If that's the case, the extent of the background checks don't vary between the agencies. The reason they do them may vary, but the information they're getting back is all the same. And I know, Commissioner, you got a lot of experience in this area. I believe I'm correct in what I'm stating.
That is correct. Anytime you use, if all the agencies are using the same purpose code, then they're going to get the same information out of it.
Right.
Where agencies differ is depending on what purpose code they actually run it.
Mm-hmm. That's right. If I'm an investigator and I'm running a criminal background under Purpose Code C, I'm getting national information. If I'm running it under Purpose Code E for employment, I'm only getting Georgia-based convictions. Running under Purpose Code W, I'm getting a different level access. So I think that's what we're talking about. That's what I wanted to make sure everyone's running under the same purpose code. The information they're getting is the same, so the extent of the background is the same no matter what agency. And then, so I think the conversation is really with Director Keenan and talking about what his feelings are on this issue and what we would need to do in state law, and also a request to the federal agency basically to state that we're running a criminal history as a state of Georgia for the purpose of child care protection agencies, period. Mm-hmm. And that's the purpose of that. And if we're all the state of Georgia, all of you are getting your paychecks from the same places like I am, we're all the state of Georgia, so and it's all for the same purpose, which is child protection. And that's why we're running the criminal history, so we should be able to share the information. That may be too simple, but I think Director Keenan and his staff at GCIC would probably, if I'm hearing you correct, would probably be the appropriate person to maybe look into that. Is that right?
I would agree with that. And I think that the secondary question is related to the timing. The way the state statute is written, I think that because we're all already using the same purpose code, we are already getting the same information. It's just the timing of when we get it. Right. So, for instance, can DJJ accept a letter the same way that RCC does for the purpose of their contracting entities, and do we place that burden of accepting a potentially 12-month-old, 18-month-old criminal record check for their new contractor, as opposed to allowing them to go and perform the record check that they think is necessary for the type of entity with which they want to contract.
And I also want to make sure, too, that the committee members understand what we're talking about, because we're really not talking about burdening, unless, do we charge for the criminal histories?
Yes.
I believe there's a charge, yes.
Yes, it's 78, is it 70, what is the cost you're charging the agency to pay multiple times for multiple different contracts?
I believe through licensure, it's 40, I want to say something in the 40s, 40 or $50.
And is that just for the criminal history?
That's for the FBI NCIS, I think.
Are they doing it based on fingerprints? Okay, so
Yes.
that's where the charge comes in.
Yes.
Yeah, and I can see that's an issue, because you're making these people do it multiple times. But
One of the things I'm confused about right now, and again, I'm just speaking for myself, and this reflects the 20 years of many, many different statutes that we've passed on seeking criminal records check for child care, this daycare facilities, et cetera, is that the technology has changed. But are you telling me that the GCIC now includes all national criminal records checks, or still only includes Georgia?
My understanding is that they include Georgia and then request, the GCIC is the hub for Georgia for the federal
But
information.
there's a national, and so when you do an employment check, do you check both? Both. You check national and Georgia. And the statutes that we've passed on and off have kind of expanded that from Georgia to national. Am I correct? Now, here's what I don't remember. I don't remember when we talked about this in the committee earlier and we wanted to do something, whether there were other states that had statutorily solved this problem. That's what I don't remember, Mr. Chairman.
We didn't get into that. I think we asked the question. I think you may have asked the question, but I don't think we have an answer. But let me back up just a second to what Representative Tanner was asking, because this is entirely different information than what I was given last Tuesday. On Tuesday of last week, I was specifically asked the question, are you telling me you're doing criminal background checks for various different backgrounds to look at particular criminal activity that may be a warning sign? For example, fraudulent, deceitful work with respect to RCC and the administration office versus drug use and exploitation in another context. And the answers I got with over a 3-hour period and within a room of members of every different agency that's affected was yes. And now you're saying that we're using one purpose code?
We have one purpose code, but quite frankly, like I said, I'm not the best authority to tell you what's encompassed in that purpose code, but I would assume, because it's the child welfare code, that you would probably still get a lot of that same information.
Okay. So then doing one check, with RCC doing one check, then if RCC does that check, or we'd have to maybe have GBI do the check, but if we're doing that annual check on all the employees for that particular licensing, then that check is good for how many days? 60 days?
No, we don't do an annual check for the licensure. There's one check. When somebody comes in and wants to become a CPA or CCI, a group home, they apply and with that application provide all of the information necessary for the criminal background check. That's the only one they ever do.
And that's good for 5 years?
It's good for 5 years, unless they have a new employee come in
which case they do that.
Let me back up. For RCC, that is the only check that they do. It's not a 5-year check. It's the only check that they do unless they've got new employees come in. So that's the licensure check. Once you are licensed, you are licensed, unless I would assume unless there's an incident or they hire a new employee. Now, when you're talking about contracting entities, those contracting entities have different requirements and their own vendor maintenance requirements. And for DFACS's Office of Provider Management, their contracting requirements require a new criminal record check for providers every 5 years. It's every 60 months.
Yes, that will be the same for the Department of Juvenile Justice because of PREA, the Prison Rape Elimination Act, calls for us to do those contractors 5 years.
And then every new employee, do we do a background check for every new employee that's hired by that particular child care provider?
Yes.
From our perspective, because you hire somebody tomorrow and someone else leaves and then you rehire, then that person needs to.
And if that agency is performing work for DJJ and OPM, is that criminal background check, is it done separately? One for DJJ, one for OPM, one for DBHDD? Or is it just one check that's done for that employee and then shared amongst the departments?
That's a good, valid question, but as far as the way that the contract reads currently, it's DJJ has its own instrument, and I'm sure it goes throughout the whole state like that. So I can see that because of the time limits of that particular entity.
Okay, I think that's what we're trying to get at.
And I think that, to me, the initial setting them up, I can understand there's going to be different timings there, but I think really the issue is every 5 years, new employee, what have you, all the agencies need that criminal background information. It seems very redundant to make them pay multiple times for it. If there's a way to work with the GBI director and the federal government to get them to agree, and if we need to make some statutory changes to make it clear that the purpose of running this is all for the same reason, which is our child care protection agencies. Because it seems to me that the feds wouldn't necessarily control who has what responsibility in Georgia, the executive branch of government. That's controlled through legislation, and so it seems that we would be able to make some tweaks to make it clear in the law that the purpose of that criminal history is for child protection agencies, and they can share that information. And then, so I think, Mr. Chairman, on page 4 at the bottom, we might want to consider changing the extent of the background checks vary depending on the regulatory agency's scope. I think that what we're hearing is the purpose that those background checks may be different. They're doing them for different purposes, but the information they're obtaining is all the same. And also, I just want to make sure to Representative Oliver's point too. GCI, if a law enforcement agency runs a criminal history on an investigation, they get the information for the entire country on that report. It's only when, and that's for other purposes, they have to send the fingerprints to the FBI. So the information is available electronically to law enforcement agencies for a criminal investigation. But under this scenario, when they're running under Purpose Code W, I think they're just getting Georgia-based arrest. The other reason that I think it's important that you do the fingerprints is because there's some states that may not share that information with other states, and they can only get it through fingerprints. So I think we need to always do background checks, but it does seem redundant, and there's got to be a way to work it out if we can just work with Director Keenan. He can work magic. So,
and if in light of the new information that we found since Tuesday, and if the scope of the intent of this particular finding is really to address the new hires and how to share that information or make sure that we've got some elimination of some redundancies there. I don't know if the committee would be open to recommending letting the agencies again have an interagency discussion about how best to do that as new employees come in.
Well, I think it's twofold. One is the new hires and sharing that information, but it's also because when DJJ contracts with a licensed facility may not, and probably often does not, line up the same year of that first initial licensure. So you have the initial licensure in 2000, and then in 2002, DJJ wants to contract. Well, in your contract, you're asking for a criminal background check because you want to have it in your file. So instead, there ought to be a sharing whereby either RCC's criminal background check should suffice for your purposes up to the end of that 60-month window, or it should not. And that's a policy decision that you have to make. But so I think it's an overlap between both the employees and that 5-year renewal of the criminal background check.
And if I hear you correct too, is maybe having the agencies change their policy to accept the letter, so that there's a letter like the other agency you were mentioning accepts. Because I can see both sides of this issue. If I'm DJJ and I'm going to contract with a group home that's never contracted with me, and they've approached DJJ and they want a contract now, I personally don't have a big rub with that agency having to do the initial background check and go through the hoops. It's just when they renew and when they hire new employees that also holds your children and your children. That's the redundancy I see. If I'm an agency that's been contracting with DFACS, now all of a sudden I want to contract with DJJ, I'm not going to have a big issue with the initial background check for DJJ because it's a new contract. But going forward, it seems like that there should only have to be one requirement for a criminal history on each new employee and each time I renew. That's the issue I personally have. If the agency's never contracted, that's in private business. If I'm going to contract with a new company, there's going to be certain hoops I've got to jump through. That's just a cost of doing business. But over time, there's got to be a way to combine some of these efforts. That's my comment personally, Mr. Chairman.
All right. With that, we're doing a lot of things at one time, so let me just make sure I keep track of it. The first thing, Representative Tanner, if we just change the word extent, this is on page 4, the second line after findings, and it says the extent of background checks. If we just change that to number, would that not say the same thing you're saying? That the number of background checks varies depending on...
I'm not sure that the number varies. I think it's the reason they're running it varies, the purpose. I'm not sure the correct word, but I think the way it reads, it leaves me with the impression that, and again, there's different types of background checks, but the type we're talking about is just doing an FBI and GCIC check, and all the information's the same. So the reason they're doing them, the purpose of the background checks vary depending on the regulatory agency scope of authority, but the information they're getting is all the same.
Well, the reason why I'm bringing it up is because the issue is not, nobody's questioning the purpose of protecting child safety or the purposes for which we're doing the background checks. We're actually talking about the number. Mm-hmm. We're talking about the frequency in which they're done and the cost associated with that is the problem. Everybody agrees, I think, that the purpose is important and significant and needs to be done. It's the question of how often and can that information be shared so that it doesn't have to be done with a frequency that's greater than the 60 months if that's not really needed. So that's why I was just saying if number would change, number would line up with the purposes for which we are kind of gathered. Purpose would not. That's why I made that comment.
Yeah, that's fine.
Okay. All right. So we'll change extent to number, and then with respect to, I think, Ms. Kane's comments and the committee's comments, it sounds like to me, if I'm hearing everyone correctly, that we really need to strike the first part of recommendation 2B, which is going to take us down, and where I would stop is where the sentence that begins, in the case of authorization is denied, and strike from the beginning all the way down to that comma and start with the committee asked the Chief Counsel to start drafting legislation that would allow for us to comply with federal mandates. I'm trying to go back to what you were saying, Representative Tanner, about giving some central authority and then talk about how that's going to be shared. And that may be something that the Chief Counsels from the various agencies can work together on to advise us as to what legislation would be needed to accomplish what you were saying, Representative Tanner.
So you're eliminating the first sentence.
Yes, ma'am, and that first clause of the second sentence.
And are we going to give them 30 days to do that? How much time would you like to give them?
This says would be back to present to us by December 1st of this year.
I see now.
So, if you would prefer
no, that's good.
A longer or tighter time frame, that's fine.
That's good.
But that gives us some time for the legislation to be reviewed by various committee members and then some vetting to be done by the Legislative Council. And while everybody's thinking, Ms. Story pointed out an important fact that the committee actually terminates at the end of this year. So the reports back that we're asking for, it would be kind of you to send those reports to committee members since we've spent the summer working on this for the last 2 months. But I think more specifically, it really has to go to a standing committee, and that would have to be, and I would recommend that we send those to the chairman of juvenile justice, Chairman Weldon, and to Chairman Willard for judiciary, and that's in the House. So if you can send those there, it'd be nice if you would courtesy copy the members of this special committee, but as a matter of just staying with the protocol that exists now, we'll send it to those 2 chairmen. Any problems with that from the committee members?
Good.
Okay.
Representative Welch, if you don't mind, the committee's asking that the Chief Counsel for DHS and DJJ draft proposed legislation to comply with the federal mandates. Currently, we are complying with. What's the intent of the proposed legislation?
I think that it's in the next sentence that in that regard, the legislation should authorize the single central agency, GBI or OIG, to collect the criminal background checks and screen against it, and then the sharing of information internally.
GBI currently does that under statute. If we're going back to what the representative was saying earlier about understanding we're a new contracting entity that would have to come in and do the background checks as a cost of doing business, is the focus truly just on the new hires, trying to find a way to share that information to maximize the efficiency for the new hires and reduce the expenditure of the child caring institution?
And renewals, I think, because right now you're having to do it every 5 years. So it would be this is just me speaking for Kevin, but it's the renewals and the new hires, not necessarily for me personally when they initially enter into the first time entering into a contract, but it's the renewal of that contract and the new hires they're hiring. And I think that's the intent of this. There may be a better way to say it, but I'm not sure. But and I think you have to work with the director of the GBI because he has probably the most expertise in this area to understand what is allowed and not allowed and what he has to do in order to get that in compliance, Georgia law in compliance, that the U.S. Attorney General would allow this information to be shared.
So will the GBI be part of this recommendation, coordination with the GBI?
We would expect that.
Fair enough.
Yes.
Fair enough.
In order to successfully achieve that, I think you're going to have to talk to them.
Excellent.
But since they have not been part of this process, I felt it was a little odd to start roping them into it in the middle of it or at the end of it. But I think the committee's sense of it is working on that a centralized collection and then the dissemination of the information out to the various departments. I think is really where the rub is. When do you disseminate it, and what will be deemed reliable and acceptable amongst those agencies?
All right, thank you.
I'm going to, with the committee's permission, I'll try to rework this language here to better clarify what Ms. Kane has raised in her comments and what Representative Tanner has suggested. Okay. Number 3 is specialized child care provider license. This was a comment or suggestion made by Together Georgia to try to come up with a specialized license for certain child care providers. And you have the findings that I've written here. Of any comments with respect to paragraph 3A? There seems to be some deliberations in the audience, so I want to give time. Does anyone want to speak on that? Mr. Scroggy?
Yes, just real briefly, talking to the representatives from Windshape and Eagles Ranch, and we just appreciate your consideration of this, and we believe there will probably be other dialogue points in the future where we can have these conversations with RCC and others to see how we can accommodate the special needs of these type programs. So just want to thank you for your consideration of those.
Thank you. And from our discussions with some of the members of, from the regulatory agencies, that those discussions are going on, have just started, and I think hopefully we'll continue.
Yes, I've had assurances from Commissioner Horton that we'll have those conversations. Matter of fact, I meet with him tomorrow.
Good. That's what I was told. So I'm going to, and what that is that the child care providers that have some specialized facilities and approaches to how they're providing permanency, they are actively working with Commissioner Horton now on having a dialogue to see what, if anything, comes out of that dialogue to adjust regulations, or possibly come back to us later with something statutorily. But I think those discussions need to be had. Those are far more detailed than I think we were able to get in these meetings. But thank you both. And the recommendation here is on page 5. It's 3B, and this is just a recommendation that we take no action with respect to a separate classification. Moving on to 4, this is balancing child safety and risk associated with normalcy. And I'll have to say that Commissioner Horton really, I think, did a good job of impressing upon to me at the meeting we had Tuesday about this constant struggle that agencies and providers are having with trying to provide a sense of normal lifestyle for a child and growing up and maturing, while also balancing that against the risk to the child and other children. And so there's an ongoing tension there that remains. And so this is addressing some of the comments that were made by Chairman Houston and others of this committee concerning just a normal living environment, as normal as can be made in these circumstances, while also allowing children to experience life, to undergo what it means to set up a bank account or to try to get auto insurance or learn to drive. The basic things that families tend to provide sometimes go missed in the child care providing realm. It's just that it's a difficult conundrum to balance. It's how do you balance that risk versus that reward of normalcy. And so with that said, I tried to solidify that into one comment as opposed to talking about any particular incidences, and that's what you have under 4. With any comments with respect to the findings of the committee in 4A? Okay. Seeing none. Any comments with respect to 4B? These are the recommendations of the committee. I did want to point out, and I really appreciated Ms. Kelly and Ms. Bryant also explaining to me that DFACS has a program that's called the Graduated Independence Plan of the GIP, and I've sent that out to members of the committee last week, or maybe it was Saturday evening, just to give you a sampling of what that is, but that does allow for a coordinated effort between the agency and the provider and the individual child to try to develop a plan that is child specific. And from what I'm learning from providers, that it doesn't, that may need to be examined again and looked at. It doesn't tend to go far enough, but that really is a far more detailed discussion than we were able to have in this study committee. So I wanted to identify it for the committee, and I wanted anyone to read this report to be aware that such a plan does exist and that it needs to be utilized. With respect to 5, this is data sharing and predictive analytics. We got into a lot of discussions about the various department agencies and their program software. And so we'll look at that. That goes from page 6 to 7 on the findings. So paragraph 5A, any comments with respect to 5A? And to make sure I didn't see online what the acronym was for Georgia Trails, is that written correctly? Page 6 at the bottom. Ms. Winstead informed me that Georgia Trails is looking at, RCC is looking at putting in a program software called Georgia Trails. That's a proposed software that they're looking at now, so I wanted to make sure I identified it correctly. But some of these acronyms are not spelled the same way you think they might be, so that's why I asked.
I just want to add that, again, this is a moving target of computer software, and there are a lot of, Chairman and I discussed that, there are a lot of smart people who are really working on these issues with various contracting, programming, trying to consolidate data, and I'm very respectful of all that, how hard that work is. I'm also aware that there's been a whole lot of progress to do some consolidation of data for the purpose of doing predictive analysis. So this is, I'm really glad the committee's talking about this, because this reflects both good work that's being done and a continuation of our emphasis on this.
All right. Thank you, Representative. So, seeing no comments on 5A, yes, Ms. Kelly. Thank you. And if I'm misidentifying your name, please correct me. I apologize if I am.
Just a small point on the introduction, and then also I see it here on page 6. It looks as if the Office of Provider Management is kind of set apart from DFACS, and the Office of Provider Management is a part of DFACS. So instead of it saying, for example, DFACS uses Georgia Shines, comma, OPM uses Georgia Score, it should be DFACS uses Georgia Shines and Georgia Score. And then on the introduction page, OPM shouldn't be set apart from DFACS. It's a unit within DFACS.
That is the way I understand it. I think because there are essentially kind of two different types of inspections. You have an OPM inspection for contracting purposes, and then you have a DFACS specific inspection for incidences. Is that right? Or is OPM doing all the inspections across the board?
No,
for DFACS?
DFACS child case managers don't do inspections; they do investigations.
Investigations.
So it's totally different work.
Okay.
But OPM does not do investigations; just the assessments when there's a quality of care concern. But Child Protective Services workers do the investigations. But it's all DFACS.
Okay, I'll make the clarification on the front page that OPM is an office of DFACS. A unit of DFACS. Unit.
Mr. Chairman, along the same lines, DOJ uses our own system, JTS, which tracks most of the information we're bringing to. Yeah, that's the juvenile trial.
Okay. Okay, well, I will make a change here to paragraph 5A to indicate that that DFACS uses Georgia Shines and Georgia Score, and then I'll correct and I'll note that OPM is a unit of DFACS on the first page. And then we'll also add to that DJJ uses the juvenile tracking system, JTS. Are those changes acceptable? Okay. All right. Now, somehow lost my formatting. Are there any changes to 5B, the recommendations? You'll note that this takes into contemplation the agency's recommendation from DHS talking about a task force. The level of detail, again, is such that it's how do you get these softwares to communicate, if they can at all, what central warehousing of information and to what extent that can be done, really takes an eye towards the details of the agencies. And the DHS has recommended that to this committee, and you have a copy of that in your folder and was sent to you, that we look at a task force that would look specifically at this computer software issue, and I have DHS had looked at having a 2-year time frame for this discussion. I've taken the liberty of reducing that down to November 1st of 2015, so that we're looking at it within the course of a year. And I'm not setting up the parameters by which the task force should be selected, but I think it should be should include child care providers. It should include some designated representatives from the General Assembly, as well as from obviously from the agencies. So I think that's just a note, but that's the sum of the recommendation. All right, seeing no changes to paragraph 5B, which is the recommendation paragraph, we'll move on to 6. Public scorecards, paragraph 6. 6A deals with the findings of the committee on the public scorecards. Are there any changes to 6A? And the issue here we're addressing, so that those that are listening for the first time, is dealing with a uniform set of scoring that would allow the public to identify how well a child care provider is doing, or a CPA is doing, so a CCI or CPA, how well they're doing in terms of ranking in the oversight that the state has to do. And if that scoring is put into some level of context, and then it should help the public, potential donors, family members that are that have children in the system feel comfortable, have a higher level of comfort that exists. Now, DFACS is already using Georgia Score, which seems to be working pretty well, and that may be the right platform to use for allowing some integration among agencies. And so that's the general gist of that particular point. Any changes to the recommendations of the committee under 6B? Again, this does require the formation of a task force to look at this, and it sets a deadline again of November 1st, 2015. I do want to say that in my discussions with agency personnel, and particularly Ms. Winstead, she brought up some very good points about that. It seems to be cyclical that we go through a period of trying to revamp the computer software systems or relook at these contracts, and what and I'm not trying to put words in her mouth, but the information that I took in from that meeting was that if you do this constantly with frequency, what you do is you're not moving the ball forward. You're just kind of standing in place because you're kind of repeating the same efforts over and over again. And then a previous effort to do this back in the early 2000s to talk about consolidation, software, communications, led to a software result that was only implemented for a limited number of months. So 2 years of meetings with only 2 or more months of use. So there is a sense that you can engage in this activity, but you can also produce a lot of wasteful time and energies if the product isn't workable. And at that time, I think Ms. Winstead had told me that DCH was in charge of that, so there may need some, and she suggested that there should be some discussions with DCH on this effort to make sure that we try not to repeat the same problems that led to a non-working system at that time. And Ms. Winstead, if I'm explaining what you told me, I thought it was extremely important that you have some historical sense of this, and that was very helpful. Okay, seeing no changes to paragraph 6B, I'll move on to 7. 7 deals with the appeal process that we dealt with in our discussions. You have the findings outlined under appeal process, paragraph 7A. Any changes to paragraph 7A?
I don't have a change, Mr. Chairman. Does the agency have timetables on the refutation process?
Yes.
Okay.
It's within 5 days of receipt of the refutation, we send an acknowledgement statement that we're in receipt of it, and then within 30 days from that, they should have a letter that spells out which reputations were affirmed, deleted, changed, and how they were changed in the new survey, if necessary.
Okay.
All right, and then turning to paragraph 7B, the recommendations of the committee. Are there any changes, comments, suggestions with respect to that?
Mr. Chairman, you and I have had a discussion, and I've been trying to understand more about the issue of a commissioner having the opportunity to accept or not accept a decision of an independent ALJ under the Office of State Hearings and Appeals. I'm going to, and I provided language which I believe the committee members have here, to make a recommendation that the commissioner eliminate his or her opportunity to approve or not approve an ALJ position. Recently, it's come to my attention that most agencies do, the commissioner, director retains the final authority, the final decision maker to accept ALJs, but recently Division of Driver Services and Professional Standards Commission have, particularly Driver Services, have changed internally their board position to where they no longer retain the right to accept or not accept an ALJ position. And I'm going to recommend that we add to a committee that within 120 days that DHS change its regulation by board action to eliminate the procedural step of a commissioner affirming or overturning a decision of an ALJ of an Office of State Hearings and Appeals. It's the intent of this recommendation that DHS eliminate the commissioner's ultimate authority of decisions made by ALJs prior to an action filed to Superior Court. There are not many cases, but I think this is an important procedural step for the providers to understand that if they're going to go through the appeal process and pay for that, that the decision does not, the commissioner doesn't have the opportunity to not accept an independent ALJ decision.
Ms. Kane.
Hi, yes. As y'all are well aware, the APA provides the opportunity for a department to, by rule, elect to have their decisions that come from OSA be final decisions. The department in this instance has elected not to do that, but instead has retained the review authority by the commissioner, because it's ultimately the commissioner's responsibility to ensure that the regulatory rules, that the rules and regulations that are passed by our board are adhered to. While ideally we would hope that would happen in the program, and it does happen in the program, we have instances where the ALJ is not intimately involved, doesn't know all of the rules and regulations. We are not represented by counsel at those hearings. The agency we are represented by agency counsel. We're not represented by the AG's office. We've elected not to move for to provide that final review for fiscal reasons as well. While Driver Services has very recently made that change, the Department of Child Support Services went in the exact opposite way in 2011. We did have all of Department of Child Support Services is a division under DHS. That division was having their decisions from OSA come out as a final review. It's enormously expensive to go to court every single time the department has to seek a judicial review. By having a final review come directly from OSA, you remove the option of the state to ensure that the decisions are correct. Quite frankly, the assumption that the commissioner is going to arbitrarily and capriciously overturn a decision by an ALJ is simply incorrect. We don't have that authority.
I didn't make that assumption.
No, I'm saying
in relation to the Child Support Division, most of those, I'm trying to figure out where an appeal would go to OSHA, since most of the child support orders are, or correct me, go through court process.
It's in the enforcement of those orders, driver's license suspensions, any sort of passport suspensions.
How many of those hearings do you have a year?
Hundreds.
Hundreds?
Hundreds. If not thousands. I mean, we can get the numbers for you.
Yeah, I'd like some more precise numbers on that. So you're not talking about the court orders, you're talking about suspension of a driver's license. And you don't suspend the driver's license, driver's division suspends the driver's license. Am I correct or wrong?
We initiate the enforcement action. So prior to having the with respect to child services, the enforcement action is what's appealable. So they will come through us to forestall the suspension of a driver's license. And then with respect to the establishment of child support orders, we do go through OSA for some of those, and those are appealable to the commissioner as well. But with respect to these particular hearings, by removing the review, it prohibits the department from ensuring that that rule is applied properly. And also, it needs to be noted that by appealing directly to the judiciary, that review is not a de novo review.
It's an any evidence review.
It's an any evidence, exactly.
I guess my respect for the ALJ system is based on, haven't been an ALJ, I guess I'll admit that, but after I was an ALJ, the General Assembly created this independent Office of State Hearings to make these 25,000 hearings they do a year into a more independent, judicially oriented entity. And it certainly was true that the AG used to represent the department in ALJ hearings. You're saying that you choose not to use ALJ for you choose not to use the AG for ALJ hearings at this time?
Not for RCC. No, ma'am, we don't. And
so which of these lawyers that are on your staff go to those hearings?
We assign lawyers for our staff to go.
So
to go
you are represented by counsel in those hearings,
but not by the AG's office.
Mm-hmm.
So we're represented by agency counsel. And I just want to also say the APA currently allows for an interlocutory appeal process. So in the event that an aggrieved person feels as though they are subject to irreparable harm as a result of a decision, they have the option to go directly to judicial review. The question is whether or not there's an irreparable harm and whether or not it's a harm that can be amended upon commissioner review by further review of the agency. So it seems as though those provisions are already there within the APA. So I'm just throwing that out there.
The first part of the recommendation does ask that you provide all these numbers. I'm looking to see, were we only asking for child service agencies or were we asking for all numbers? Because you're raising issues in here that we've not heard before about child support recovery services using OSHA and those being quote-unquote thousands of hearings you just said.
I said hundreds, perhaps thousands.
Okay, so you're going to give me specificity on that. But does, Mr. Chairman, are we asking for specificity on that or not?
No, I think that was, I was trying to get at this idea that having some sense of the numbers of appeals that go through would be illuminating to the committee. And I think we need it in as broad a sense as well as specific to RCC. But I think we also need as broad as, we're going to need a breakdown of the numbers into different classifications. If you have some recommendations, Ms. Oliver, I think that would be good to tell the agency exactly what you want. We can add that to the committee's report.
I do not want the commissioner to have ultimate right to reject an ALJ decision on the issue of child placement agencies. I'll withhold judgment on the child support recovery matter until I really look at the numbers and how many times the commissioner is overturned. I'm trying to speculate as to what the legal issues would be at a child support recovery hearing, hundreds of which. I mean, I can understand somebody appealing based on not wanting to lose their driver's license, but I don't know what the legal issue would be before an ALJ other than whether or not he or she has paid their child support. But that's where my mind is going right now. So if you give me these numbers and whether or not the commissioner has overturned ALJ decisions, that'll help me. But for the narrow purpose of this committee, for this particular issue, I would like to offer an amendment, in addition to the committee, that the commissioner, that the board eliminate the procedural step of commissioner affirming or overturning the decision of ALJ in OSHA directly relating to an issue of child care service provider only.
Any thoughts from members of the committee? Is there I'll take that as a form of a motion to amend. Is there a second on that motion?
Second.
Okay, Ms. Chandler seconded the motion. Discussion from the members of the committee?
So if I understand it correctly, the board, the DHS board, this would be a recommendation from this committee to the DHS board to consider changing their policy that's in place to take that authority away from the commissioner. They could choose to do that or not do that. And then secondary, is there any other state agency where the board itself hears an appeal instead of just one individual that you know of?
I don't think so. I don't think the boards sit in any kind of quasi-judicial or appellate.
So they used to, but they used to do that, but not now.
So this recommendation would be that DHS board remove the authority through their policy power, regulatory power, take it away from the commissioner, so that the whatever the correct term is for the state administrative hearing process, that would be the final appeal. And then if the department was not satisfied with it, the next step would be to go to Superior Court.
Yes, sir. That's what the Administrative Procedures Act says.
Okay.
But I'm amending this red language that I've given you just to directly limit it to issues relating to child care agencies.
And
So there'll be CPAs and CCIs.
Right.
I just want to be clear that the DHS board cannot remove that authority without going through without promulgating a rule pursuant to the APA.
That's what I've said here.
Okay. Excellent. Just
And the
wanted to
chairman
make sure
will
that was clarified.
clean that up but that's my intent.
Okay, thank you.
And you're going to give us those child support issues numbers
No,
also.
specifically, would you like to know?
I'd like to know how many hearings from all of DHS come out of ALJs with ALJ decision in categories, and how often the commissioner rejects an ALJ decision. But my recommendation is only relating to the narrow subject we're dealing with here.
Any further discussion on the motion? All right, the motion is to amend the recommendation of 7B to include the language that you have before you in red, but it will be specified to apply to CPAs and CCIs. I'll take a vote on that motion. All those in favor of the motion as I've described it, say aye. Any opposed?
Aye.
Okay. 2 in favor. Okay. All right. 3 in favor. And Ms. Houston, can you hear us? We may have lost her. And then any opposed? Okay. All right. I'll amend the
Thank you.
report accordingly. Thank you, Representative Oliver. And then last we have Part 8, which deals with tax incentives for sponsorship of foster children. This is just an attempt to try and incentivize the private sector to contribute to providers and help them with sponsoring children, particularly those that are at the AWO level or MWO level at higher needs. The system seems to be taking in and handling children at the baseline level, but the financial difficulties come with a higher need child. So any questions or comments, changes to 8A of the findings of the committee?
Did you have in mind at any point a cap on that? I didn't.
It does not say that, but I'm willing to. Yes, ma'am. I wanted to keep the cap minimum. Actually, I'm in the process of drafting some legislation on that with a $2.5 million cap.
Okay. And that's for the individual child, or is it a donation of any, if I paid income tax of $2.5 million and I wanted to donate all of the $2.5 million, is that how it's worded, or do I have to do it per child?
It would be a sponsorship to the agency, and the agencies would accept it based upon the children with the elevated needs.
So not one child, but
not one child.
Okay.
It'd be tied to the children that are coming into the system. So if you are Chris Kids, for example, and you're accepting children with at an MWO level, then the number of those children you're going to sponsor would determine how much money could be dedicated to that provider.
And this is a tax credit? I mean, you use the word incentive, but I'm not sure what that means.
It would be a credit, yes, ma'am.
Okay. Thank you.
You want to add in here a cap of 2.5 then?
Yes, sir, thank you.
Any objections to that being added? Okay, and I'm going to change the word from tax incentive to tax credit.
Mm-hmm.
Any objections to those changes? Okay, very good. All right, we'll add those to it. Any changes to paragraph 8B? These are the recommendations. I'm going to change that to credit as well there in 8B. Taxes, change tax incentive to tax credit. Seeing no objections, then I'm going to, are there any other items that members of the committee wish to either add, subtract from the overall recommendation? Representative Oliver.
Chairman and I have discussed this issue of substantiated child abuse for children who are in care. And that's something that is the federal government and a lot of other entities in oversight follow carefully. It was one of the elements of the Kenny A case. What is the rate of re-abuse for children who come into the state care? And that's a pretty important factor. And what I want to just this committee to highlight is in the findings, and you have this on the red stuff that I've added as a potential paragraph 9, is that based on some data that Ashley was helping me with in the last few days, there are over 500 substantiated cases of abuse and neglect for fiscal year 13 for children in custody of the state care. I'm aware that next year the state's on a rotation to have a review of this kind of data and other, and I'm going to request that we add this paragraph that we're aware of this data, that 38% of these over 500 are relating to children who are in child care service agencies or child care placement agencies, the private providers, and that we recommend that when the data comes out in the next federal review, that the chairs of, I'll change that to the chairs of the Juvenile Justice Committee and the Judiciary Committee receive a copy of information related to that re-abuse rate, so that we committee members will get a copy of that as a courtesy copy, and we'll be able to follow these issues closely because they're important. So my recommendation is not any direct action other than we be advised of the next year's review of the substantiated abuse rate for children in care. I'd like to know whether it goes up or down.
Mm-hmm. And I'll take that as a form of a motion.
Yes, sir.
Do I have a second on that motion?
Second.
All right. It's been seconded. Representative Tanner. Any discussion from the committee members? I have just some questions. Representative Oliver, would you explain to the committee where the numbers are coming from, the 500 substantiated child abuse and the percentage you have there in the recommendation, or the findings, I'm sorry?
Yeah, I sent that to you. I think I did. I hope I did.
You did. I just want to make sure that everyone else knows about it.
Ashley, at the early, one of the PowerPoint figures early in, I'm looking for Ashley right now. I'm right here. Okay. Early in PowerPoint, you had a figure of 470 abuse substantiated records, and I asked you to get some detail of that, and you did, and you were very helpful at kind of breaking it down as to where those allegations came from, where they were substantiated, and you've updated that based on our ongoing conversation, and you have given me specificity as to where the 568, I think was the number, substantiated cases have come from for children in care.
I do want to clarify, those are investigations. Not all were substantiated. The 38% of the substantiated. This 38% is correct. The 500 is actually the number of investigations. And I'm frantically trying to pull up on my BlackBerry the full number of substantiations.
You sent me an email with an attachment at 5:56 Friday, if that helps you.
Yes, ma'am. And that's for the number of investigations.
Mm-hmm.
Not all of those were substantiated.
Do you know how many were substantiated?
I'm trying to search that
I
number
think
right
you
now.
earlier had said 470 something.
Those were 477 referrals from residential child care to Child Protective Services.
So we're not
That's
sure how many of
correct,
these 572 are substantiated?
It's 572 investigations. If you give me just one moment, I can pull up the
Okay.
number of the substantiation.
It makes sense that you would get a higher rate of referrals from a child care institution because there are more eyes watching. You know, the incident of abuse of neglect that's never reported is where nobody's watching. And in these institutions, a lot of people are watching. But it's just a figure I'd like the committee to follow, and that's the point of my recommendation.
Okay, well, we'll do this. If you allow me, we'll try to get the exact number of the 500 versus whatever the number it is.
I will allow you. I'd be grateful. I'd more than allow. I'd be grateful if you would clean up those numbers.
I think the only question is with respect to the 500. So
572 is what she's got there on her document.
we have 572 investigations, and then do we just want to revise that to say that there are more than 500 investigations of the child abuse?
Yes, that'd be fine.
All right, let's just do it that way, and then we know we're on solid footing with that finding. So we'll change it from 500 substantiated cases to 500 investigations of abuse, and then we'll make the changes to whom this information will be sent as the chairman of juvenile justice and chairman of judiciary.
Thank you.
Representative Tanner, is that okay to make that change? Yes. All right. Any other comments or thoughts with respect to Representative Oliver's motion? We'll add that as item 9 to the list. And seeing no further comments, all those in favor of the amended recommendation say aye.
Aye.
All opposed? Thank you, Ms. Houseman. All opposed, like sign. Okay. There won't be any because everybody's unanimous. All right, good. One last thing I'd like to just point out this, we didn't get into this in detail, but as if the task force are formed, then it would be helpful that we look at conflicting regulations where there's tension between a RCC regulation and a DFACS regulation. Some of these, I'm hearing from child care providers that, that there are one regulation may require one outcome and the other from another agency pursuant to their contract requires a different, and that they are mutually exclusive. So they have to decide, well, do I want to lose my license or do I want to get a lower score, or Georgia score? And what the default is, well, I'll take the hit on Georgia score in order to keep my license. So when we look at those scoring processes, I think it would be helpful to try to look at where there's a conflict and tension between those two agencies. To the extent they exist, if they're mythological, then we'll deal with them at that time too. But I, again, finally want to just say thank you very much to the committee. And I was going to change multi-hour meetings to the front, but I'm not going to change that now. Thank you all for suffering through lunch with us today, and I appreciate everyone's help on this project. Before we go, though, I need a final vote on the entirety of the recommendations. You have before you a list of now 9 recommendations with their findings and the associated recommendations. With the amendments that we proposed today, I need a motion and a vote on a motion and a second on accepting these recommendations.
So moved.
Okay. All those in favor of accepting the House Study Committee on licensing inspections of child welfare providers report of findings and recommendations for 2014, say aye.
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 Any opposed? Seeing none, the recommendations are adopted. We will have those out as soon as possible. Thank you so much.
Good job, Mr. Chairman. Good job.
Thank you.